Welcome to the WineDown, an afternoon podcast where two techie blokes sit down over a bowl of wine and chat about what's happening in the world of tech. Enjoy while Scott and Nick open up about their week in technology.
Well, ladies and gentlemen, hello and welcome to the WineDown. I'm Nick and this is
Scott.
Hello, Scott. How are you?
Hello, Nick. How are you going?
I'm very well indeed. Now, where are we? What are we drinking?
We are in the DY Hotel.
Again, cool,
Again.
excellent.
How about that? It's easy. It was close.
Yeah, no, that works, absolutely. It's close to my house. It's not close to him, but there you go. More importantly, what are we drinking?
We are drinking, and this is an interesting drop. This is the Cab Merlot 2018 Little Demon. It's a Maxwell wine. And look, it's a good pub wine.
Where's it from?
South Australia, McLaren Vale. And look, it's if you look at the back of it, you normally expect something that's going to tell you about what field the grapes came from and how hard they were to pick and the time of year and how they squeezed each one individually. No, this is some cryptic story about something about. I'm not actually sure what it's about. It's very weird.
Oh, well.
Anyway, I suppose that's why they call it Little Demon. But you know, it's not half bad.
So I'm trying to make a segue into our topic today, but I'm struggling because our topic doesn't really segue. MSP legal agreements. This sounds like the world's most exciting topic, Scott.
Look, it's of all the things we've spoken about, this would take the cake for being the dull item of the year.
I would say when I was chairing CompTIA, which is the Computer Trade Industry Association Australia's group, I kept saying we should get a lawyer to come and talk to all our members, and everyone was like, no, really boring. Yeah, I know some great lawyers who give great, really interesting talks. Law's actually quite fascinating in different ways, but people think it's very boring. So we'll do a boring talk on it, shall we?
Let's see if we can jazz it up a little bit. But look,
jazz it up.
Exactly. Let's say when you're a company and you work out that, hey, my IT's got some problems, I want to get someone in to help.
Yep.
I need to get either like a managed service provider, or maybe I just want to get a company in to do the old break-fix thing from the 1990s to come in. But hopefully you're thinking more strategically about IT and looking at managed service provider sort of levels. So let's say that a company comes in and says, hey, we can do this, we can do that, we'll help you with all your IT, blah, blah, blah. And you say, yep, that sounds great, off you go, just give me an invoice. That's all very well. What happens when something goes wrong?
That's an interesting point. So if I think about it, if I go to a shop and I buy something and I bring it home and something goes wrong, well, I'm covered by consumer guarantee laws.
You've got Consumer Law and Trade Practices Act and so forth.
Yeah. If I buy a piece of equipment and it fails within warranty, I've got some comeback, right?
That's right.
But if I get somebody to come in and do some services, and it's different with tradies, right? So if I get a licensed tradie, I've got recourse. I've got the Consumer Affairs Tribunal. I've got all sorts of things. But that's back in consumer land, isn't it?
You do, but there's also things like that's when something, for example, goes very wrong. Like, I need you to dig a hole and put a pipe in, and you dig a hole, and, for example, your building falls down.
Oh, yes. I wouldn't know anything about that.
No, I wouldn't. No, that's just a first thought that came to mind. So, that sort of thing. And you'd think that in that sort of scenario, you go, you made my building fall down. You're responsible for this. And they're saying, oh, well, not quite. No. And there are legal agreements that control all of that.
So I suppose if I think about it at a really high level, IT is quite complex.
It is.
And IT people understand some of it, not all of it. It's a big topic. Business owners don't understand a lot of it. So it would make sense to write down what you're going to do and what you're not going to do, right?
Yeah, and look, here's the thing. If you're going to get an IT provider to come in and help you manage your network, update your equipment, look at all your data along the way because they're copying it, they're backing it up, they're helping you with... You want to put some basic protections in place. And this is what we call the Master Services Agreement. This helps both you and it helps the service provider because it really spells out how the relationship works.
Yeah, it was really funny when we started migrating accounting firms from one practice management tool to another. Very often, early in the relationship, the accounting firm would go, well, should we send you a copy of our data? And we go, no, we haven't signed an agreement yet.
Yeah,
right?
And look, as an IT provider ourselves, I don't want to get involved in any customer's network not knowing we've got confidentiality agreements signed off and that we've...
So it's protecting both parties, right? It's
It does.
not a one-way
No.
document.
It works both ways because all of a sudden the customer says, oh, look, come into my network, play with that, and you do something in there, and then a week later they get breached. And they'll say, well, that was your fault. You've lost all this data. We've had... No, it's not my fault. I didn't do anything. You get all this back and forth. The legal agreement really explains how the interaction between both parties works.
Now, I should say before we start, we're not lawyers, right?
We're not
The
lawyers by
other
any
day
means.
when we did Bitcoin,
That's right.
we're not financial advisors either.
No, one day we'll work out what we are.
Yes, but none of this is legal advice, right?
This is not
none
legal
of this
advice,
at all.
but look, let me tell you a little bit about what is in a standard legal agreement, just the basics. You can read these, they're pretty dull, but
This
to
is
be
more
honest,
an MBA view of a
okay,
agreement
an MBA
rather
view
than
of
a
an
lawyer's
legal-
view
Yes,
of
there
an
was one
agreement.
legal subject in my MBA.
That'll
and
do then.
This covered the majority of it very
I'm just
quickly.
thinking of, I have some friends who are lawyers and we don't want to diss they know loads of things,
No,
right?
but what they will say though is that first thing when you get into trouble, where's the agreement?
Yep.
And you go, well, there's no agreement. They're going to, well, okay, well, that's a bit of a mess, isn't it?
Yes.
How did you get yourself into this mess? So look, there's a concept called a master services agreement. And it is an overarching agreement that says this is how the relationship between the person providing the service or the company providing the service and the end customer works. There's a number of sections in it.
Okay, but this is not, I would have thought this is not an agreement you get with every quotation, right? Every quotation references that agreement. But
That's
once
right.
that's signed, that stays as the
That's right.
ongoing. It makes life simpler, right?
And normally what will happen is you'll see a quotation from someone and there'll be some fine print down the bottom, not too fine hopefully, because you should be able to spell this out and say, if you agree to this quotation,
Yep.
it is governed by the terms of our master services agreement shown on the website here or attached to the back or given to you at the time, whatever it is.
Cool.
But it needs to be available, and ideally, you should be signing that master services agreement, or you should have easy access to it to be able to see it.
So that's cool. So there's this agreement, and it really, if we ignore the legalities of everything, it writes down what the gives and gets are between the two parties.
That's right.
Sets the correct expectations.
It does, and this is this really is just as much for the client as it is for the MSP.
Okay.
Any MSP today going out and doing work in client networks without a basic agreement in place showing, we are doing confidentiality, we are talking about intellectual property, we're talking about a whole variety of things.
Talking about that, why don't you unpack some sections for us?
Okay.
Confidentiality
Okay.
you mentioned. Let's start there.
Confidentiality. It's a basic confidentiality clause that says, look, as a provider, if we go into a client network and we see information that is considered confidential, that could be anything starting from personnel information.
Yep.
It could be backups, it could be reports around profit and loss, it could be how much stock the client's got on site, it could be anything to do with their business.
You certainly get to see some crazy things in IT, right?
And as an IT provider, you get to see all of these things, one way or another, you get to see them. Then we say, look, we're going to keep that confidential for you. We're not going to go and, oh, look, this is interesting, I'm going to go and tell the press and quickly go and buy some stock.
Or tell a competitor or something.
Oh,
We just don't do
that's,
that.
That's right. This is the whole thing. And so we put that in writing and say, we're going to keep that confidential. The same thing.
I will say, so unlike doctors, right?
Yes.
We don't sign, as IT professionals, we don't sign this overarching code of ethics. Right?
No.
So this is all written in that agreement.
Having said that, I wouldn't say the industry is completely unethical.
I'm not saying that either.
No.
I'm just saying the IT industry isn't governed the same way accountancy
That's
is,
right,
or the legal profession or others. Although we're trying to get there, we're a slightly newer industry.
We are. I think it'll take a while because we've rushed ahead quite a lot.
So that agreement is your key document.
Yes, the legal agreement is the key document. Now, look, confidentiality works both ways. It also says that you, the provider, if you go and share how you do things or some secret ways of doing things or even some of your own approaches to people and staff and whatever, you know that the client's not going to run and say, oh, look, hey, this is what these guys are doing, what's everybody else doing? So, oh, hang on,
Good point. And that takes us into intellectual property, right, as well?
It does.
So what is intellectual property? Remember, this is not legal advice, this is just Scott's opinion.
That's right. So intellectual property, let's say that I'm a service provider, you're a client, and you say, hey, Scott, come along and write some software for me.
Yep.
And I go, oh, sure, I'll do that. And I go and write some software and create something new in your industry that really gives you that competitive advantage.
Mm-hmm.
And I look at that and I go, here's one person in this industry that was willing to spend money to do this. What if I go and find 10 more like that, and I go and sell that same bit of software to those 10 other people in the industry? I bet they're willing to pay me a bucket load each time, and I've already written it.
Yep.
This is a gravy train. I've got to get in on this. And because I developed the software, I'm saying I own it. Therefore, I can do whatever I like with it. And you're, as a client, going, hang on, I just paid you to write this thing. What do you mean you're going to go and take what I've just paid for and go and sell it to other people and make more money and give them the secrets that you've just developed? Welcome to intellectual property.
Yep.
So what we would normally do in this sort of case is it says, if this is a scenario where you want to make sure you are the only one that has this bit of software once it's written, let's put that in writing and spell it out as intellectual property.
And we changed the price on it, right, as well, because our business, because I run the software business at TribeTech, our business is about building software that we can sell to lots of people.
It is.
So,
it is.
So if a customer came to us and said, that's fine, I want this, you're going to build it, you're going to have to go and sell it to other people, that's fine, I'll pay M dollars for it.
Yes.
Now, if they want to keep that intellectual property and have that theirs, well, it'll just cost them more.
That's right, because that says we're not allowed to do anything with that later.
Yep.
And if we went to another client and they said, I want you to build this, this, and this, and we said, that's very similar to what we did over here, it wouldn't matter, we'd have to start from scratch.
Yeah.
That's
Yeah,
right.
Absolutely. Okay, so that's written in there, so we understand what that is. Indemnities, what are those?
Indemnities are things that say, like, let's say I send an engineer or a technician to your site, and they trip over a power cord that you've got lying around and break their leg.
Yep.
We're saying, okay, well, look, you need to indemnify us against the fact that this person's hurt themselves on site. It wasn't our site, it's your site, and clearly it wasn't kept in a very good condition if this has happened.
Yep. So that really is an agreement. Most organisations have that stuff in
place.
It
works
anyway.
both ways. It's a very simple thing, and in most cases it's covered under public liability insurance. But it just sort of spells out that, look, if we do things, we are going to indemnify you, the client, against these things, and you are going to indemnify us, the provider, against these things.
That makes sense.
And you make sure your insurance agreements cover those, and that's that.
So that's cool. Liability and limitation thereof. Now,
Yes.
I know from my basic business school that a limited company limits the liability of their shareholders to their investment.
That's right.
Weird if you're a director, but
Yes.
but otherwise not.
So-
So here you're trying to limit the liability. So let's say, for example, computers break.
Okay.
And if we took over a manufacturing environment, for example, and the whole plant was run by a single machine from 1998,
Oh, yes.
and that machine broke, and they lost millions of dollars because they couldn't produce stuff, it's not really our fault.
No, that would be true, because the chances are that thing would have failed anyway, regardless of whether we were there or not.
Yep.
If we had done something, though, that, not intentionally, let's say accidentally we did something to cause that to break, we could be, in theory, liable for part of the cost of fixing it or of the business's operation. And the limitation of liability clauses spell out which parties are liable to who for what.
That makes sense.
And normally there's a limitation that says, look, I'm going to limit this to the fees that I've been received over the previous 6 months or 12 months or something like that. Sort of thing where if you paid me $1,000 to do a job and I did something, I couldn't be liable for a massive amount beyond that, because
Right.
you're not paying anywhere near that.
Yeah.
And it sort of brings it into
Cool.
place.
And again, in most of these agreements, those terms are all negotiable.
It is.
And it all comes down to money at the end of the day. It's all about
It
price.
is.
So talking about payment terms.
Yeah. And it basically says, if I issue you an invoice, you'll pay in 14 days.
Yep.
And if there's a problem, I can add interest. And if you pay early, maybe you get a bonus or something. I don't know. But it basically just sets out basic stuff like that. So everyone is very clear on how this works.
No, that makes sense.
If you don't do that, you could, I could issue you an invoice and just say, oh, look, here's an invoice for this month. You say, oh, great, thanks for that. You just say, great, I've got it. Yeah, I'm going to pay it at some point. maybe in a year's time, maybe in 2 years' time. Where does it say I've got to pay it in 14 days? You didn't put that in any agreement anywhere.
Yeah, no, for sure. Cool. Termination.
And look, of all things, this is one of the most important clauses in there. So we have master services agreements. We've had them for years and years and years, and I can tell you that when we go to larger clients, and like finance companies, insurance companies, and various things, we normally get to have a lovely session with their lawyers, normally in-house counsel, that will go through the agreements and make sure that the company, their company is protected. They largely ignore the majority of the agreement because it doesn't matter so much.
It's normally templated anyway, really.
Yes, but what they do, they start at the termination clause, and they say,
how do we get rid of it?
How do we get out of this agreement if it all goes wrong? What have we got to do? And they make sure that they understand that really clearly.
So that wraps up into dispute terms, right?
It does.
How do we handle a dispute? How quickly does it have to be rectified? When can we exit?
And look, dispute terms say if something does go wrong and you both can't agree on something, there's normally a clause in there that says the matter will be forwarded to a body, an independent body, where a mediator or an arbitrator will be appointed, and they will hear both sides and make a decision, and then both sides have agreed to abide by whatever that decision is, good or bad.
And so we're going in with a friendly business agreement. Neither of us want to end up in court.
That's right.
Let's find a way not to do that.
You don't want to end up in court on these agreements. All of a sudden, it's an agreement that you're spending $5,000 or $10,000, whatever, for turns into a $200,000 court agreement.
Yeah, you don't want to do that.
It's those court costs really go high quickly.
So no employee.
So if I'm a provider, and I start to put people on site doing things for you, and you say, oh, hey, these guys are pretty good. Tell you what, why don't we just hire them directly? And all of a sudden I go, well, hang on, I've just lost key people. A non-employment clause says you agree as a client you're not going to hire my staff. Equally, it says that if I'm providing you a service and I put people on your site and they see, hey, there's some really good people here that are sort of interested. You're not going to hire them either. But it says we're not allowed to hire them either. So it just sort of means that there's no concern about staff disappearing. Either way, if you go in there.
Cool. Warranty. This is an exciting one.
Okay. Well, look, there are warranties under law, but there's also, you may have some other warranties against whatever you're doing. Professional services. You warrant that you are putting people appropriately skilled in to perform the service that you have sold to the client. And
that's really important. And you are, and that's critical. You certainly wouldn't get someone off the street and get them to go and muck around with someone's production databases or something
that's just it. And all of a sudden you talk, well, why are you doing this in my database? And what's a database? Oh, I just learnt this in my book last night. It said I typed this. And so clearly that person would not be an appropriate resource to fulfill a contract that says you've got to do this.
For sure. Now, if I'm thinking as an MSP, and you've got a bunch of these contracts and master services agreements signed and a bunch of annuity revenue, that's the value in your company, right?
It is, and the fact that it's all done properly and it's all bound under the agreements.
So there's an assignment clause. Does that handle the scenario where you get acquired, or
it can, or if the client gets acquired. So you need to be able to either assign the clause.
The contract.
Sign the contract, thank you.
The clause. Use the clause to sign the contract.
So it basically says that if there is a change in control in either the provider or the client, we are allowed to reassign the contract to the new provider.
Right.
If there was an acquisition, either the provider is acquired or perhaps the customer is acquired, legally it says that the agreement can go with the acquisition.
Okay, now that needs to happen, I understand that. Now the last one, I see this all the time, I read this in agreements, from employment agreements to all sorts of things. These terms, and I'm not asking you to define a legal term, there are lawyers which do that.
Yes.
But there is something which says these words, entire agreement.
Yes. So let's say you come to me and say, I need help with my IT. And I say, oh, that's fine. We can do this, and this is a managed service. Would you like this? By the way, this is our master services agreement that explains all the bits and pieces behind the scenes. And you go, great, I'll sign off on that. I come back a week later and I say, oh, what if we went and did something else and this is a different agreement? You say, oh, that's fine, off you go and do that. Now we have competing agreements.
Yes.
The whole concept is that the latest version of the Master Services Agreement that's signed now becomes the entire agreement between you and the client.
Okay. Does that also affect the fact that, quite often you'll sit down with a client and you'll blue sky a whole bunch of things you're going to do.
Yes.
And then eventually, because we'll all negotiate on price and things, we land on these are the things we're going to do, these 10 things. They end up in the entire agreement. That stops the client coming back and say, but you said you were going to...
That's right. If it's not in the agreement or it's not in the proposal that attaches, that is governed by the agreement...
so it's not written down, it doesn't exist.
That's right.
Okay.
You can't say that if I say I'm going to do A, B, C, D, and E, and you say, well, where's F? So, well, we didn't say we were going to do F. This is the entire agreement.
Okay.
And
So
it is a bit of legalese, but it really sort of makes it very clear that if anything goes wrong, here is how the contract works.
So luckily the entire agreement was the last step of unpacking those bits, because I'm sure that was mind-numbingly boring for some people, but that's cool.
Yes.
But yeah, we've talked about this. This is our opinion of what these are, right? This is not legal advice.
It's
so
very high level.
Go talk to a lawyer?
And hopefully we got them more or less right.
Yeah,
but
we'll
go talk
to
a lawyer. The more important message here is make sure you have a master services agreement in place.
Yep.
That tells you about this is how we're going to manage the relationship between us and another party.
And really those agreements are the best way to manage risks, right?
Well, they are, and I would look at it a slightly different way, saying I would not go into a relationship without having one of these in place.
Cool.
It's a scary thought. Because
So I wouldn't get someone to come and start work without one of these in place, right?
No, why would you? Because if you say, oh yeah, come look at all my data, come do this, come play with that. Oh look, you stole my data, you broke that, you went and stuck this stuff in a place that wasn't supposed to be.
I do remember
Why would I do that?
I was called in by a client in this massive rush. I had to fly down on a Sunday and all sorts of things. And before I even touched the plane, I went, here's my agreement. And it's for electronic signing, it's all good, but until that's signed, I'm going nowhere.
Yeah.
There's no point. It's silly, and that works. I think it's the level of professionalism you need to do, right?
It protects you as well as protecting the client.
Yeah. Scott, that was awesome. That was kind of fun.
It was in a dull legal sort of way, I know.
21 minutes of sheer pain I'll never get back. But no, that was awesome. I appreciate that. And thank you so much for watching and listening. And make sure you give us a like, give us a subscribe, leave a comment if you'd like us to discuss something. Yeah. We'd really appreciate it.
And please be nice on the dull legal topic.
No, you don't have to be nice at all. You say whatever you want. I was passing straight to Scott. But thank you so much for watching or listening. You have a fantastic day.
Thank you, everyone.
Bye. Bye-bye.